In this video, I want to quickly outline the framework for infringement of registered trademarks under the Australian Trademarks Act. So a person infringes a registered trademark when they use, as a trademark, a sign that is substantially identical or deceptively similar to a registered mark in relation to either the same goods or services, closely related goods or services, or unrelated goods or services where the registered mark is a well-known or famous mark. So I want to quickly provide a brief definition of each one of those key terms. So first, the concept of use of a trademark. For a trademark to be infringed, the defendant must use a sign or a similar sign in a way, or in the course of trade, in a way that attempts to distinguish that person's goods or services. So the important point to remember is not all uses of registered trademarks will be infringements. Uses which merely refer to a particular product or a brand or other descriptive uses of a trademark term are not going to be infringements unless they're used in a way that is used as a trademark. And use as a trademark means using the sign in order to distinguish one person's goods or services from another. And the authority for that is Shell and Esso, High Court case in 1963. The next term is substantially identical, or substantial identity. And this involves looking at the two marks, the one that is said to have infringed the first one, and carrying out a side-by-side comparison. And in this side-by-side comparison, the court will look to the similarities and differences between the key elements of the two marks, or the two signs, sorry. If the infringing mark, or the allegedly infringing mark, is not substantially identical, it might still be deceptively similar. So in this case, rather than doing a side-by-side comparison of the two marks, what is important is the recollection or the impression that a person, an ordinary person, would be likely to have of both marks. So in this case, the court will look at the recollection of a person of ordinary intelligence and memory would have of the registered trademark on the one hand, and compare that to the impression that a similar person would get from the allegedly infringing mark. And you see that again defined in Shell and Esso. So now we come to the definitions of the different types of infringement under section 120. So the first category is the most straightforward, the vanilla case of infringement where a registered mark is used, where the allegedly infringing mark is used in respect to the same goods or services that the registered mark is used in or registered for. So this, for example, very straightforward approach to infringement enables a quick finding of infringement where, say, a manufacturer or a retailer of a cola-flavored soft drink uses the term Coca-Cola. It's very clearly the same goods or services, and the analysis ends there on the infringement case. It gets slightly more difficult where we're dealing with goods or services that are not exactly the same but closely related. And in this case, section 120 sub 2, where the issue is whether or not a member of the public would ordinarily expect the two types of goods or services to be sold from the same business or supplied by the same business. So, for example, in Gallo and Lion, Gallo Winery owned the Barefoot trademark in relation to wines. Lion Nathan sold a beer with the trademark, under the label Barefoot Radler. And in that case, the court was able to find that beer and wine were closely related goods or services, that you could expect the same supplier to supply both types of goods. And in that case, an infringement could be found. The final category is where the goods or services are completely different, unrelated goods or services in section 120 sub 3. So normally the general rule is that if they're unrelated, then there is no infringement. A trademark is only valid in respect to the particular types of good or services that it is registered for. However, where there are well-known marks that are well-known in Australia or famous marks, the situation is a bit different. And you can infringe a famous mark by using a similar sign in a way in relation to unrelated goods or services, but only if the mark is so well known that consumers would likely form some sort of association, would likely think that there is a connection with the owner of the registered mark and the allegedly infringing goods and services. There has to be that connection in the minds of consumers or potential consumers. And it only operates, this section, where as a result of that connection, the interests of the registered owner would be adversely affected. So this doesn't prohibit all uses of famous marks, only where those conditions are met, where there is a connection drawn or a likely connection drawn between the consumers thinking of the famous mark and the way that the mark has been used in the new context or a similar context, and only where as a result of that connection the trademark owner would be harmed in some way. So there's a bit of debate about whether this is actually a dilution section or not, or whether it's just extended protection for some classes of well-known marks. In particular, we don't have a lot of case law in Australia to work out whether this extends to cases where there is no likelihood of confusion. So that's the basic outline of the three different categories of trademark infringement under Australian law. Importantly, for each one of those definitions that I've just outlined, we use the same tests. So for substantial identity, deceptive similarity, closely related goods or services, we use the same or a very similar test, and it operates in very similar ways under both infringement in section 120 and the tests for registration under section 44. So we'll deal with each one of those in turn.